Hi, I'm Rob Massa. I'm the Managing Director of Qualified Plan Advisors in Houston, Texas. I'm also known as the Retirement Pro, the 401k Guru, or the Foracle. I want to welcome you once again to my blog. In today's edition, I'd like to discuss the complications related to attorney-client privilege and ERISA plans. Now, thanks to the myriad of evening police and legal TV dramas, most Americans are really quite familiar with the concept of attorney-client privilege. Put simply, this privilege helps to ensure that all litigants receive a fair trial, since all communications between a client and their lawyer are confidential. However, when dealing with ERISA retirement plans, we encounter a bit of a conundrum. ERISA plan fiduciaries have both a duty of loyalty and a duty of prudence, which essentially requires them to take actions solely in the best interests of the plan participants and the beneficiaries. Now, this sometimes means that attorney-client privilege afforded to plan communications discussed with legal counsel may not always apply in the way employers, plan fiduciaries, and authorized plan fiduciaries might expect. Plan fiduciaries conduct an extensive amount of communications in the fulfillment of their duties under the plan. While some of these communications are naturally quite public, such as fee disclosures and enrollment materials and summary plan descriptions, other communications such as meeting minutes and benefits determinations or even vendor selection discussions are meant to carry more discretion. Now, sometimes fiduciaries may engage legal counsel to provide advice on a variety of issues to ensure proper application of the law or regulations. However, any communications, discussions, or decisions that are fiduciary in nature between an attorney and plan decision makers wouldn't actually be considered protected from a potential discovery in a lawsuit brought by the participants. For example, if let's say legal counsel attends a quarterly investment review meeting with the plan fiduciaries, any discussion about plan fees, services, and investments would likely be discoverable by the participants in a lawsuit. Now, you may wonder why having such a discussion in the presence of counsel wouldn't be protected under attorney-client privilege. And I would tell you, in short, it is protected. It's just not in the way you might think. Because the fiduciaries represent the plan participants, the attorney-client privilege is actually between the participants and the attorney present in the room. Since retirement plans are actually trusts managed on behalf of another party, the fiduciaries are really simply acting on behalf of the participants and thus almost become an extension of the participants themselves from a legal standpoint. In these situations, it's the participants, not the employer or plan sponsor, that's the client. Does this mean that all communication between the plan sponsor or plan fiduciaries and legal counsel are subject to discovery? No, it doesn't mean that. For example, if a plan decision is not fiduciary in nature, then any communications between the plan sponsor or plan fiduciaries and legal counsel would not likely be discoverable by the participants. And we call these decisions settler functions, and they can be critical in the operations of any plan. Examples of settler decisions include items such as the decision to establish or terminate a retirement plan, deciding on or changing the matching contribution, or even the physical drafting of plan documents and summary plan descriptions. Any conversations between legal counsel and the plan representatives discussing these types of matters would likely be protected since they're not fiduciary decisions, but rather more business decisions in the implementation of the plan. Another example might involve any discussions between counsel and a plan fiduciary when receiving advice on how to defend themselves against claims of personal fiduciary liability. Such conversations would also be protected and not subject to discovery by the participants. Now, this may seem like a contradiction on what was discussed earlier, so it's easier to explain this through example. Let's say a plan fiduciary has provided a domestic relations order in the divorce of a participant or spouse. The fiduciary first has to determine if the order is qualified and then attempt to implement the division of benefits under the order without violating the plan provisions. If either the participant or the alternate payee later sued the fiduciary for a breach, the decision-making process that led to the decision itself would be subject to discovery. However, any subsequent conversations between the fiduciary and the attorney they hired to discuss the matter with and plot their defense is privileged and can't be disclosed in the lawsuit. Now, as always, let's talk about some best practices you can consider when trying to determine, in this case, whether privilege applies and how you should respond. First, make sure you understand whether what you're discussing with counsel is settler or non-settler in nature. If it's a settler decision, decide whether you want to keep these discussions separate from non-settler conversations. Next, if your goal is to have a conversation with counsel that is subject to privilege, make sure you only include the necessary parties to the conversation. For example, if you're using a fiduciary investment advisor to help your plan, one like me, Remember that the advisor's job is to represent the plan and the plan participants. So conversations that include the advisor are not likely to be privileged since counsel does not represent the advisor, and thus the advisor would be required to testify what he or she knows. Instead, if counsel needs to ask questions of your advisor, have them query the advisor separately to keep them out of the loop of communications that you might prefer were subject to privilege. Also, be careful of using your company's general counsel in these discussions. While general counsel represents the company, they aren't formally in the practice of law, and they don't necessarily represent the plan fiduciaries. Even though plan fiduciaries are usually company employees, it still creates a potential disconnect since the plan fiduciaries have a fiduciary duty to the plan and its participants that is separate from general counsel's interests. I'd like to thank you for visiting my blog again. I hope you found this latest installment useful. If this is your first visit, please check out some of my other content on my YouTube channel and like it and share it too. If you need more information or assistance on any retirement plan related matter, just contact me on LinkedIn by clicking on the QR code right here or email me at rmass@qualifiedplanadvisors.com. And as always, I'm wishing you and all of you a very successful retirement.